Hi, I'm attorney Eric Lewis with Lewis Legal Services in Indianapolis. Today I have a quick video about a recent case that was decided by the Indiana Supreme Court regarding an appeal that had a very harsh result for a woman who tried to respond to a lawsuit without a lawyer. And the Supreme Court even said, and I quote, "This case presents an unfortunate cautionary tale for individuals who represent themselves in civil litigation." Essentially what had happened is there was a small car dealership of some kind that borrowed money from a lender. And as part of this financing agreement, the car dealership and its business members, who consisted of a husband, wife, and the wife's friend, all signed this promise to pay. And when the business defaulted on the loan agreement a couple years later, the lender sued all of them. The wife, instead of hiring a lawyer, chose to respond to the lawsuit with a letter that she sent to the court saying that she never signed the loan agreement. That bought a little bit of time in the case, and then the lender filed what is called a motion for summary judgment, basically saying that they had the law in their favor, including an affidavit authenticating the execution of the loan agreement in front of a notary public. In response, the wife again sent another letter to the court, again denying that she had anything to do with the loan agreement. The court held a hearing and then granted a $160,000 judgment in favor of the lender against all the parties. The business, the husband, the wife, and the husband and wife were now divorced, and of course the wife's friend who also signed the loan agreement. Except as it turns out, she didn't sign it. According to this Supreme Court opinion, after the judgment was granted, the husband sent a letter to the court saying that he wanted to appear in court to prove that he forged the signature of his ex-wife and her friend on the loan documents. The ex-wife even timely filed an appeal of the judgment, but because she didn't file the required brief, the appeal was dismissed. Later, the lender tried to force collection of the judgment, and the ex-wife finally hired a lawyer to help her out at that point, but it was too late. They tried to show the court the fraud involved, but there were a number of procedural missteps that didn't allow for that to be considered. So in this case, the Indiana Supreme Court, which has 5 judges, made this decision by a vote of 4-1 that due to the procedural mishaps, the decision was to stand despite the confession of fraud on behalf of the ex-husband. And in the end, the case was not decided necessarily on substance or merit. It was decided on procedure. And the court stated, and I'll paraphrase, that while it is regrettable that the wife failed to timely file sworn affidavits or properly designate evidence to show that she did not knowingly sign the contract, the ex-husband's fraud didn't keep her from doing so. The evidence of fraud did not therefore warrant the relief requested. Now, one judge wrote a dissenting opinion that he didn't agree with the court's analysis, but the decision was 4-1. And this poor lady had to suffer the consequences of not handling her case with the correct procedure. And this is unfortunately very common. People think they can handle all kinds of cases without a lawyer, but the problem is you don't know what you don't know. And the smallest procedural time frame or rule can doom your case. And I hope this video was helpful to give you something to think about when it comes to pro se litigation. If you like the video, please click subscribe. Subscribe to the channel, like the video, and as always, thanks for watching.